So there's an SSA 581 form that's prepared by the Social Security Administration that allows a worker to obtain their employment history and their wage record. And so we can determine who was paying the worker's wages during certain years, and that can be very helpful. The Department of Labor assists in terms of verifying employment, and very often they can verify certain types of employment, but that can be a challenge as well. It just depends on what the situation is. Very often we have claims where it's very difficult to prove employment. If a worker worked at many different facilities during their job, or if the contractor for whom the worker worked had jobs at the Department of Energy facility or atomic weapons employer facility and at other places off the facility, then it becomes difficult to prove whether the worker was on site. That leads to the form EE4, where we can get a statement from a worker, co-worker, that the worker worked at the facility during a certain time period. Those statements are simply signed statements. They don't need to be affidavits. And those can be submitted and can provide the necessary evidence of employment. This leads to kind of another issue, a controversial issue, and that comes up, which is that the claimants themselves, their testimony, whether it be at an informal hearing or in a letter or signed affidavit, whatever it might be, is very often ignored by the Department of Labor. And that can be very frustrating for us as attorneys and for claimants as well. There just appears to be a view that the self-serving statements of a worker will not be considered. It's our hope that that changes over time, and certainly that is one of the issues that we try to bring up with the Department of Labor when we meet with them. So once we have submitted the evidence to the district office, there are a number of district offices. There's the Ohio District Office, the Denver District Office, the Seattle District Office, and the Jacksonville District Office. The claims are managed from the outset at the district office by a claims examiner. The claims examiner, once the claim is fully developed, prepares a recommended decision. And so if the decision is a recommended decision approving compensation, we fill out a form that waives objections, assuming we don't have any objections to being compensated under the circumstances. And the file then goes to the final adjudication branch, where a hearing representative is assigned, and the hearing representative writes a decision. Now that process, first of all, the entire process can happen in a matter of 4 months. On a perfect claim that sails through the process, we can get from filing the claim to payment of the claim in 4 months. That's not a typical time period, but that is kind of the inside time period. To the extent that we slow it down because we can't get the right records, that lengthens the time period. Sometimes the Department of Labor slows it down. They get busy, and it takes them longer than it should from time to time. But the Department of Labor is very focused on doing this quickly, sometimes at the expense of the claim, but the Department of Labor is definitely focused on getting the claims processed quickly, and they're very proud that they've reduced the number of days that it takes to process the claims. They have various markers, various goals that they set, whether it be 75 days for the processing of a claim or 150 days from the date of the objection. They have time periods that they work within that they try to meet and that they are evaluated on. So that's always an important issue, is when is the claims examiner or the hearing representative's deadline to have a claim adjudicated. So once the recommended decision is issued by the district office, the claims examiner in the district office, the file, the physical file, goes up to the final adjudication branch. And the final adjudication branch is charged with writing a final decision or returning the file back to the district office for further development. That's called a remand. Sometimes the case will be remanded back to the district office for further development. This process is supposed to take about 30 days, and sometimes it takes a little longer, but that gives you an idea of where, what the timing is generally, or what it's supposed to be, and then when they get busy, sometimes those deadlines slip. Now, once a recommended decision denying a claim is issued, we have 60 days to object to that recommended decision. And then once we object, it's generally approximately 150 days that the hearing representative has to hold a hearing, which takes about 2 months to set up the hearing, and then another 30 days. So about 3-4 months to get through the hearing process. The hearing is an informal hearing. It lasts 60 minutes. We do them by telephone pretty regularly, but they can be done in person. There are also video conferences, video conference calls that can be set up. So there are a number of options there. It's, like I said, it's an informal hearing with a hearing representative and the attorney or advocate and the claimant. Just lasts 60 minutes. It's a very, it's not a very difficult process. These claims are decided for the most part on the documentary evidence, and so the testimony given at the oral hearing. Now, the oral hearing is taken down by, recorded and taken down by a court reporter, so a transcript is generated, so that becomes part of the file, and the hearing representative must review the transcript of the hearing and prepare and review all the evidence in the file and prepare a final decision or a remand order sending the claim back to the district office for further development. That process takes about 4 months, and then lead to a final decision accepting the claim, a final decision denying the claim, or a remand back to the district office. And that generally describes the EEOICPA claims filing process.